I'm Mari Frank, and I've been an attorney in California for 35 years. I'm happy to give you some tips on how you can avoid an attorney-client fee dispute. I've been a mediator for the Orange County Bar program on the attorney fee dispute issues. And so I've seen a lot of disputes between attorneys and clients and tried to help them resolve it. So this way, by helping you today, I'm hoping that you'll avoid having to go through that. So let's begin. First of all, when our clients come into our office and they get a retainer agreement, they immediately feel a lot of pressure, and hopefully not this much, but do you promise to pay the bill, the whole bill, and nothing but the bill? Even though it's a joke, I think a lot of our clients really feel that way, and they're under pressure, they're having a conflict, they want your help, and this is another problem for them, is how to deal with their attorney and payment. So let's talk about the standards for the attorney fee billing statements. We have to look to California Business and Professions Code section 6148. So you can go over that yourself, but I'm going to give you some of the key issues. First of all, an agreement is voidable if we don't follow the requirements of a reasonable fee and a reasonable retainer agreement. So if you don't follow the requirements, and if you do have to go before a tribunal, then you'll find out that you have to prove reasonable fees, and you'll have to bring in a lot of your documents, your settlement agreements, your whatever you've prepared to show that you have a reasonable fee, and then quantum mero it, which is a lot harder to prove than just showing reasonable billing statements. Okay, so the billing statement must include your rate, whether it's $200 an hour or $500 or $700 an hour, and it has to be reasonable, commensurate with your experience. Then the dates of service in chronological order. So every time you put down a date and the reasonable billing that you're completing there, you have to make sure it's in chronological order. I had a mediation recently in which the attorney had like October 30th and then October 15th and October 2nd, and the billing was all over the place. And then as I went through it more carefully, I saw that there was double billing. April 15th was twice, and the same service. So you've got to be very careful that you use a billing program that is going to help you to do everything in chronological order and show the rate, the dates of service, and show the service provided. It's important to say something like PC, phone call, RE, maybe the settlement offer, or make it very clear what it was and make sure the date is there. So if you're sending them emails, for example, are the emails showing the date that you have on your billing statement that also show the date in your email file? Also, what's the basis of the calculation fees? Are you charging, like I do, 6 minutes, which is 0.1 is 6 minutes, 0.2 is 12 minutes, or are you doing 10 or 15 minute intervals? Make sure that you calculate the fees and show them what 0.2 and what the actual rate is and how much you're charging them for each section. I had another case in which they put how much time, but not how much they were charging until you got to the bottom. And then you would have to spend the time to calculate each service. It was crazy. All right. Then the cost should be delineated. The cost of the deposition, the cost of the filing fee, all of that should be delineated in a separate section that is not part of your actual hourly billing. If you do hourly billing, if you do a contingency fee, you need to clarify that in your billing statement of what your costs are. Okay, what else is required? Well, you must provide the bill within at least 10 days of the request by your client. However, it is best practices and expected when you go before a tribunal that you send your billing at least once a month at the beginning of the month so that they can see what was used up of their retainer, or they can see what's going on with your contingency if you've had depositions or if you've had other costs that have been accumulated. So at least once a month. And then the client must understand the billing procedures and the rates. So if they call you and say, I don't understand this bill, you should not be charging them to explain the bill. And it's best practice to the very first bill is sit down with them, or at least by Zoom, go over the bill with them so that they understand what it is and how it complies with your retainer agreement. You must provide notice of an increase of your hourly rate. So I had a client, a couple clients that came in for a mediation of a fee dispute. And what ended up happening was the retainer agreement had one billing rate, and yet on the statement, they were charging $50 an hour more. So that is going to be considered voidable. So you must provide notice in writing so that you give the client a chance to say, wait a minute, I'm not comfortable with this. Maybe I'll find another attorney. So you must give notice before you start charging an additional amount on your fees. The billing should tell when the payment is due and how payment is to be made. If it's due in 10 days, if it's due in 30 days, is it to be made by credit card? Are you accepting credit card? Are you accepting Zelle? Are you requiring a check, cash? How are you asking that they be paid? That should be at the bottom of every bill as well. And then here's some questions to ask yourself. Is your billing statement consistent with your fee agreement? So we just talked about that a moment ago, but it's very important that you talk about that you ask yourself, am I really consistent with that retainer agreement? Am I charging 0.6 or am I charging 0.2, or what am I charging? How am I charging? Am I charging 6-minute intervals, 15-minute intervals? How am I charging? And is it fair considering my experience and my expertise? Are the legal services adequately described so that someone can understand what work was performed? Was it a settlement agreement that you prepared? If that's, 10 hours, is that considered reasonable? Or is it maybe an hour or an hour and a half? That's going to be looked at by the trier of fact if you have a fee dispute. Is it really reasonable? How many pages was the settlement agreement? And so you need to make sure that you delineate what you're doing. If you're talking with the client, if you're talking with the other attorney, what you're doing, don't lump it in to prepare settlement agreement. Have each item separate so it makes more sense to everyone why it was the amount of time that it was. Are the hourly rates for each timekeeper identified? So if you have a paralegal at a different rate, is it clear that it's the paralegal or an associate or someone else that you are charging an hourly rate for? Is it easy to understand how much time was spent on each task? So that's what we talked about a moment ago. Is it easy to understand that if you are writing a letter, maybe that's 0.3, but a settlement agreement might be 1.2. So you need to be real clear, and the least smallest or the least denominator should be clarified. So just take each section of what you've done and make it very clear on your billing statement. Here's some more questions to ask yourself. Are the costs itemized? So instead of saying travel expenses, do you have maybe mileage is one item, hotel, another item, and meal, another item, if you're charging for that, if you're going out of town, parking, all those things should be separate line items. And are your billing statements sent out each month in a timely manner? So if you're sent, and that means that you don't want to have a billing statement that is sent out once every 6 months. I had a mediation in which there was a client who was upset because they kept asking for a billing statement, and you have to provide one within 10 days, at least, once a month. And what happened was this client was a family law client, and the attorney had not sent out a bill for 6 months. And then the client got a bill for $32,000. So that was a big upset. And of course, the client was outraged. And it wasn't even clear in the billing statement what was what. So make sure you send a monthly statement by the beginning of every month. And if you're sending the billing statement by email, electronically, remember, this is a confidential communication, so you should be encrypting it and give the password to your client. So we have, for every client, they get their own separate password for what we're sending them that is confidential or for their billing statement. So make sure that if you do send by fax or by by fax or by email, that you have it protected as well. And if the agreement is voidable, how are you going to prove the quantum merit of what you've done? Think about that ahead of time, because you will not be able to collect on fees if you're not following the requirements that for your retainer agreement and your billing statements. So just remember, you deserve to be paid without a dispute and in a timely manner. So prepare all of your billing statements in accordance with Business and Professions Code 6148. And remember, there's no way to succeed in business without the highest ethical standards. And we all have a duty to comply with the Business and Professions Code and our rules of professional responsibility. So thank you for listening, and I hope you get paid handsomely in a timely manner and do great work for your clients. Thank you.